this for June 1st at 2:15 p.m.
No, I'm not available on that day.
Okay.
We already moved some stuff on that day.
Okay, June 22nd then. Final pre-trial will be July the 6th at 2:15 p.m. And trial date will be August 14th. And I don't remember the other hearings, I assume do you have an email, computer, man, or phone?
I have a phone, but not a computer.
I can have her come to my office, Your Honor.
All right. Okay, let's do it by Zoom. Pre-trial. All right. Now, regarding the other case, 22098, pre-trial, Ms. Collins is present by Zoom, and Mr. Armstrong in the courtroom, so I mentioned this is a client. The defendant is charged with 5 counts, counts 1 through 5, involving all misdemeanors and forfeiture. And I believe this is set for trial on June 27th, so this is the first pre-trial. Final pre-trial will set for June 1st, so we'll have to get a different date. We won't put that past anyway. Looks like both papers have been provided, discovery, and the defendant pre-trial motions other than to reschedule the pre-trial.
No, Your Honor, and actually we have already rescheduled that.
Okay. All right, and has been a written plea offer?
There hasn't, and I still owe the state discovery back, Your Honor. I'll have that out.
All right. That's due by final pre-trial. All right, anything further than on that case?
No, Your Honor.
All right, thank you.
Your Honor, that first pretrial was moved from June 1 to June 22.
On the new case, yes.
Okay, thank you. Thank you.
All right.
Your Honor, Nancy was pictured and printed on the 98 charge. Does she need to do that for the new charge also?
Yeah.
Okay, so you have to do that.
Every new case has to have a booking.
Wait for that.
All right, Stephanie Fleming. Stephanie Fleming, attorney there from the jail. All right, this is case number 21CR162, State of Ohio versus Stephanie P. Fleming. Mr. Fleming, the attorney, is Patrick Hafner, he's appearing by Zoom. Also, the prosecuting attorney, Ms. Collins, is appearing by Zoom. The matter of court status conference, I've been presented the plea of guilty form. Now, this afternoon, you and your client both waive for personal appearance before the court and be able to conduct this hearing with Zoom.
I do, but right now, something else has come up. Right now, just a minute to talk with her breakout room.
Well, actually, you can take several minutes, I can go ahead and do a sentencing that Mr. Armstrong here on.
Okay, that'd be great.
All right? All right, I'm going to put you into a breakout room then, Ms. Fleming, with, she will get Mr. Armstrong. Go ahead and do Mr. Kramer, Sloan. Sloan, Mr. Sloan here, okay. So I'm going to put you in a breakout room, Ms. Fleming, and it's going to come up on a screen, join breakout room with a button, and you'll need to click on that. And then you and your attorney will be talking alone. No one else will be able to hear you or see you. And when you're done, there's a button that says leave breakout room, and you just click on that. And while you and she are talking, I'll be doing the sentencing hearing. So, and 10 minutes. All right. Slow, come on up, have a seat. All right, this is case number 21CR206, State of Ohio versus Joshua Sloan. Sloan is appearing in court with his attorney, William Armentrout. The responsible attorney is actually appearing by Zoom, but we also have some Zoom hearings scheduled this morning, and so Mr. Armentrout is here. The defendant has entered a plea of guilty to retaliation, a third-degree felony. Matter was referred for a pre-sentence investigation. The court has received that, at least the attorneys received a summary.
Yes, Your Honor.
All right, Ms. Collins, anything on behalf of the state?
Let's continue with the plea agreement, Your Honor.
Armentrout?
I would ask the court to follow the plea agreement and place Josh on community control. Having reviewed the pre-sentence investigation, I was, of course, aware of his misdemeanor convictions, but in reading this, it's pleasant to read it. He actually did what he was supposed to do. It looks like he's almost completed his drug counseling, has opted on his own to continue with that. He's fully employed. I believe that he would be a candidate for community control, and would ask the court to so order.
All right, Mr. Sloan, is there anything that you would like to say?
No, Your Honor.
The victim of this offense, Ms. Collins, was in agreement that the defendant should get community control.
Yes, she was. Yes, she is. In agreement with that. We spoke with her back on February 28th.
Well, Mr. Sloan, court had a little skepticism about this plea agreement, quite honestly, when I read it, when I accepted it, and that's one of the reasons I want to mention that so it's not binding on the court, because retaliating against a police officer is a particularly egregious offense, in my view. And he made a lot of really serious threats. Reading the summary, it does appear that she was high and either drunk or on drugs and acted kind of cool. And that context is such that it didn't appear that there was any real planning about it. You were just spouting off. Although I do see that in the truthful record, you got three just assault with a peace officer. No, and that's concerning. But there is a good report on you from the FRS, indicating that you have, as Mr. Armstrong said, been doing what you're supposed to do. I'm not too crazy about your THC medical marijuana card. Medical marijuana, in my opinion, is just a legal scam that the state has adopted regularly because people complain about the various things that they have, and therefore, pot helps them relax, blah, 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 blah. There have been exhaustive studies conducted on the medical effects of marijuana, and to date, there have been no scientific studies that have validated it. It's just that, in my view, and many other people, particularly in the treatment community and drug court community, that it's just another way to self-medicate when people are not using amphetamines, opiates, cocaine, different things like that. But at this point, you're managing. So I'm going to give you the benefit of the doubt. I'm going to order to be put on control for a period of 3 years. In the supervision of the probation department, these conditions, your bail laws, all those things of all my manner of conduct, report and directed, to be truthful in all statements you make to the probation department regarding your condition. Keep them informed of your residence, place, employment, all time, management, and change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You must have a copy of that passed with you when you leave the state. Do not enter upon the grounds of any correctional facility nor attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not to possess, purchase, own, use, or have under control any kind of farm, ammunition, dangerous orders, weapons of any other type. You're not to purchase, possess, use, or have under control any controlled substance, drug abuse. I have CBD oil and kratom in there for the same reasons that I just explained to you. Or any variant or analog of any controlled substance that have effects similar to controlled substance and drugs abuse. Any instrument, device, or thing may be used to administer them, prepare them administration unless you have lawful prescription, copy of which you must provide with a 24-hour receipt. There submits drug testing whether to ask requested. You're not to purchase, possess, use, have under control any alcoholic beverage, or be present in places sold, may be consumed, even so unlawful. You're not to associate with anyone who is a co-defendant, in this case, or has a criminal record, any member of the gang or the criminal group, or any person who could influence you to commit a violation of these conditions or offense. May not after the date of this order, marriage, establish cohabitation, and common marriage type relationship with another person who doesn't apply to previous relationship, then new relationship, without written permission. May not, we must support any contact with law enforcement, address citation, conviction, or other charge violating the law not later than the next business day after it occurs. You provide your supervising officer with financial information records so you will pay these fines and costs due. If you are referred by the probation department for any further evaluation or assessment, any other kind of treatment, counseling, therapy, or other training program, we'll submit to that. If there's any programming recommended, you'll roll in successfully complete. Pay the court costs of this action and agree to I make payment arrangements to do that. And there's no restitution, correct? Alright. You successfully complete the FRS treatment program and any recommended aftercare. Now, by being put on community control, rather than being sent to prison, you're deemed to consent to a search without a warrant of the person, your residence, your vehicles, or any other property, place, vehicles, where you're found or that are in control of any time, any probation officer or an employee of the department. If you don't find imposed, your court cost is a subsequent order, and if you don't make those payments, the court could have that collected in the clerk's office by levying bank accounts related to earnings. That doesn't affect that harm. The court may order you to be served, you express to each other work, and after they set by the court, each other work, you should have to find that amount to pay full. Now, in the event that it's alleged that you have failed to comply these conditions, the probation department will file a notification in writing to the court so it's filed upon you. And if the hearing will be entitled to have an attorney, and the outcome of that hearing is that you have failed to comply, at that time the court will revoke your community control and sentence you to prison for 29 to 36 months, provided by law, fining $10,000. If that happens, once you complete the prison term imposed by the court, the adult control authority could, at their option, place you under post-release control for a period of up to 2 years. If they determine during that period of time that you have failed to comply, they should return you to prison. They can serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations that have committed a felony. Whatever sentence the judge in the felony case imposed upon you, that judge also authorized the sentence in this case, an additional period of 1 year, whatever time left on that period, or greater, that occurs, that may be served consecutively the sentence in the case. Alright, that completes the case. You're no longer on pretrial supervision, house arrest, etc. Should report down to probation immediately after court, so they can send you out for felony supervision officer over the term. Any further counsel?
Hang on.
Alright, thank you.
Thank you, I'm
Sorry.
sorry.
Oh, okay. Okay, back to that. Alright, we're back on the record.
Come on.
Okay, we're back to record State versus Stephanie Fleming. The defendant or attorney had a breakout session now. We went through it, complete this afternoon.
We are, Your Honor.
All right, now, Ms. Fleming, you're agreeable to this sentencing or this plea being taken by both testimony, you during the jail rather than being present in the court. All right. Now, you are charged along with the co-defendant in 4 counts, first 4 counts of the indictment, 2 counts of aggravated trafficking, methamphetamine, 2 counts of aggravated possession, all of which are second-degree felonies. The court has received a plea guilty form that indicates you're going to plead guilty to count 1. Now, this is a form that the prosecutor's office prepared from their computer, and I'm going to hold this up to the screen for you to look at. And this is the first page, has your case name, number, and plea guilty form. See that there? You recognize that form? Pardon me? You recognize that? Okay. And on page 2, page 3, at the bottom of the page, there's a sentence that says, I enter this plea voluntarily, and then there's a signature line that looks like Stephanie Fleming. And I'll hold that up to the camera as well and ask you if that is your signature there at the bottom of the page I'm showing you.
Yes, sir.
And do you recall when you signed this agreement, Ms. Fleming? All right.
Few months ago, Your Honor.
Okay. Well, I know there have been some, there's a period, I think this case has been in active status for a while. So, have you gone over this agreement with your attorney before you signed it? You understood at that time that it was an agreement to plead guilty, and that that meant there would not be a trial, and the next step in your case would be a sentencing hearing?
I wasn't aware at the time, I'm not really sure who the law is.
Okay, well, do you understand what's in this agreement? Have you seen the agreement recently?
Your Honor, we spoke about it, went out for the screen at the jail, talked about it again, and I confirmed with the prosecutor that it was still a valid offer, since it had been a while, and then I agreed to our breakout session. So, it has been a while since she's seen the agreement itself.
Okay. All right, well, all right. So, Ms. Fleming, you still want to go through with this plea agreement that you signed back in October?
If I can do rehab, maybe?
Pardon me?
Rehab?
What about rehab?
Like a really rehab?
That's not my question. That's got nothing to do with what I just asked you. The question is, and this is a charge carrying a mandatory prison term. So there's no possibility of you going to a rehabilitation facility. It requires a prison term. There's no ifs, ands, or buts. I don't have any discretion. And that's what, and if you don't know that, then maybe we need to take postpone your hearing so you can meet with Ms. Hacker again and go over it. Okay. All right, well, I'll go through it. I come from an era when we didn't have any plea agreements. We just did everything on the record anyway. We now have plea agreements because we want people to be able to read them and take their time to understand what's going on. So that's the concern I have here. So, first of all, if you enter into this plea agreement, that means there's not going to be a trial. The agreement states on page 1 that you're going to plead guilty. Count 1, aggravated trafficking, methamphetamine, under section 2925.03A1, a second-degree felony. And under the law, that carries a prison term that's mandatory of between 2 and 8 years that is imposed by the judge. I can pick any number between 2 and 8. That's a mandatory number. You have to serve every day of that. There's no early release. You have to serve it. Now, under the law, that is the minimum sentence. The maximum sentence is half of whatever prison term is imposed, as determined by the Department of Corrections. So, if you were to receive the worst possible sentence of 8 years, after you serve that 8 years, the Department of Corrections could decide that you should serve an additional period of up to 4 years. And that means that the possible sentence range for this offense then is 8 years minimum mandatory up to 12 years. There's also a fine of up to $15,000. There's a mandatory fine of $7,500 and a license suspension of 6 months to 5 years. You understand that? All right. Now, are you facing any felony charges anywhere else? And are you on probation, community control, parole, or post-release control, or felony from any other jurisdiction? All right. Now, under the law, as I indicated, is mandatory prison term, so community control is not possible. It's probation. That's been stricken off of the plea form that you signed. It's been stricken through the law. Now, count 1 alleges that on or about February 4, 2021, in Highland County, Ohio, you and Richard A. Kupalon did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, in violation of Section 2925.0381. So that's the charge. Now, do you understand what it is that you've been accused of having done, when, where, how you did it? And you understand the possible penalties for that offense? And actually the mandatory penalties. Okay. You understand that it's a mandatory prison term offense. Right. Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise, possible possible outcomes of the trial with your attorney? And are you satisfied with their advice and confidence in this matter? Are you currently under the influence of any types of drugs or alcohol? Are you taking any prescription drugs? Antibiotics only? Okay. Those don't affect your ability to understand or communicate. Has anyone threatened you to make you plead guilty here today? Now on page 2, there's a language. I'll hold it up to the camera to show you what I'm going to read you. See that language there? It's printed in bold and underlined. I'm going to read it to you. Do you see what I'm talking about? All right. It reads as follows. Defendant shall under plea of guilty to count 1. State will dismiss the remaining counts. State defense jointly recommend 3 years incarceration. As consideration for the plea, defendant will cooperate, testify truthfully against co-defendants, pay back bond money in the amount of $1,310 to Highland County taxpayers. Now, is that your understanding of the plea agreement? Has anyone promised you anything other than that to get you to plead guilty here today? Now, under the law, Ms. Fleming, the matter of sentence is up to the judge, not the parties. So even though there's an agreement that you ought to get community control, the court is not bound by that. So if you plead guilty, once I've heard all the information that's been presented, if I decide that's not the correct sentence, I could impose any sentence that I think is appropriate between 2 and 8 years that the law permits me to impose. And you understand that? Now, do you hold any license or certification from any state governmental agency regarding that regulates any occupation or profession? All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have the right to have an attorney to represent you, and I appointed Ms. Hattner to do that. Now, that wasn't simply to work the case out, but to provide any defense that could be available under the law that you wish her to provide. So, if you decide you don't want to take this plea agreement, that you want to defend against the case, she'll continue to represent you, including a trial, if that's what you want. You understand that? Under the Constitution, you have the right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are subject to jury duty under your trial. After they are selected, the evidence will be presented, they will be instructed on the law, and then that jury will decide by unanimous verdict whether to state truth or guilt or reasonable doubt. Now, and again, that unanimous verdict means all 12 of them have to agree. Now, in the event that she did not want to have a jury trial, that she didn't want to plead guilty, then you could waive the writing, which means give up, right to have a jury trial, and in that case, you would have to call a bench or court trial, which means that instead of a jury hearing the evidence, it would be the judge hearing the evidence, apply the law, and decide whether or not to state proof beyond a reasonable doubt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine your attorney. What that means is the witness against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that? Now, under the Constitution, Ms. Fleming, you have a right to use the power of the court to compel the court witnesses to go to court and testify for you, just like the state. What that means is that the witnesses against you have to come into court and testify here in the courtroom in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that? Under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence against yourself at any time, including trial. I will never make it specified. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, which is if there's a jury trial and you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that? Under the Constitution, you have presumption of innocence, which means presumed innocent until proven guilty by the state of Ohio on every essential element of the defense charge. So you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your defense. You may, but you're not required to. Whether you do or not, for the proof will remain upon the state to prove your guilt and prove beyond reasonable doubt on every essential element of the defense charge, which is the highest burden of proof known under the law. You understand that? Now, originally you pled not guilty. Not guilty plea denied the allegations in the indictment as to all counts, denied you committed a crime and exercised or invoked all the rights I've just described. You change your plea today from not guilty to guilty. That's the opposite of the guilty plea, not guilty plea. Guilty plea admits the allegations in count one, that's their crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you, except the right to have a jury trial. I'm sorry, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to have a jury or court trial. Waives, gives up the right to confront witnesses against you and cross-examine through your attorney. Waives, gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you the same as the state. Waives, gives up your privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you could have had up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other circumstances, you can file an appeal. That appeal would have to be filed within 30 days of your sentence and entry being filed. You understand all of that? And are you a U.S. citizen, Ms. Fleming? And are you entering into this agreement to plead guilty voluntarily? So despite the fact that you signed this document back in October, you understand what the terms of the agreement are today? And you still want to go forward and plead guilty in accordance with that? Do you need to talk to Ms. Hammer about anything else before we go any further? All right. All right, you should get the message there to hit button join, and when you're done, hit leave. And Mr. Kramer, you're there at, or I'm sorry, that's Mr. Taylor, you're at the start. All right, as soon as we get done with this other case, Ms. Hammer's your attorney, we'll do your pre-trial so you can get back to your program. Yeah. We're back, all right. All right, we're back on record. Now, do you have, any, questions about anything I've explained to you here this morning, Ms. Fleming? And then it's your decision to go forward, plead guilty, to the plea agreement, pursuant to the terms that I've discussed with you here, on the record this morning. The answer to the charge of count one was alleged on or about February 4th, 2021, in Huntington County, Ohio. You and Richard and A. Kugelon did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance of amount equal to or exceeding 5 times bulk amount less than 50 times bulk amount of violation section 29.5.03A1. A second degree felony carrying a mandatory prison term of a minimum of 2 years up to 8 years set by the judge, with the possibility of whatever term is set by the judge being extended by up to 1/2, 50% by the parole authority, or by the Department of Correction. A fine of $15,000, a mandatory fine of $7,500, a possible license suspension of 6 months to 5 years. How do you plead? All right, the court finds on this day of the court, defendant provides of all constitutional rights, a knowing and intelligent voluntary waiver of the same pursuant to Rule 11. Please accept the order filed. The defendant is found guilty of count 1 as charged therein. Counts 2 to 4 are dismissed as to this defendant. Now, the agreement indicates that the request for pre-sentence investigation is a mandatory sentence. Is there really a need for that?
There's no reason.
Okay. All right, then, the court then will proceed with sentencing forthwith, and not order pre-sentence. Ms. Collins, anything you'd like to say?
Your Honor, I would ask for the law my recommendation that law complaints have prior to if these charges are serious, because the hearing is for a certain issue, but prior to the terms of the pre-trial provision, you did make the factor aware this morning that I will not be seeking an indictment for failure to appear. She hasn't been informed in this case. Gosh, back in November. She was pregnant at the time. During the time the case was pending, was tested positive. But I did also advise the time for them to be arrested. This has been on her outstanding warrant. We searched her hotel room where she was staying and found four suspected men as well as women.
Which is not part of the agreement.
No, it's not.
And you agree that is happening?
I do.
All right.
Mrs. Collins, I did have a discussion about this.
All right, so Ms. Fleming, you understand that there won't be any indictment sought for failure to appear, but there could be another indictment for any drug charges if testing results show that what they found, well, that's what they said they found was controlled substance. You understand that? All right. Okay. Ms. Hapner, anything you'd like to say?
Thank you, Your Honor. Originally, I had trouble with asking investigation because this woman was pregnant and something that they were required to live in a prison center. Obviously, at this point in time, she has given birth. Her baby is over 3 months old. And she would ask if she got the opportunity to see the child before she is shipped off. So we would place that on.
Okay, Ms. Fleming, anything you would like to say? You're not required to say anything, but I'll listen to your finance say.
Yeah.
All right. Well, Ms. Fleming, you don't have any previous record, and that's a good thing. But unfortunately, when you decided to get involved in criminal activity, you went for the big time. You didn't mess around with no minor leagues. You went right to majors and committed a major league offense. And, it's very very serious under the law, required to be sentenced to prison, okay, same as your behavior since the charges indicted were on bail, not been very good either, and quite honestly, typically, in a matter like this, I would probably take that into consideration and impose a sentence beyond that which is recommended, because of the lack of cooperation and consideration for the court's orders. But since this is a mandatory offense, and it is possible that it could be extended by the Department of Corrections, depending on their analysis, because you have taken responsibility and you're also going to potentially face other charges on other matters, I will go ahead and probably agree in my sentence. So it's the order of the court. It should be in our hereby sentence to a mandatory term of 3 years of incarceration at the Ohio State Court for Women at Marysville, Ohio. Now, that sentence could be extended by up to 1/2 by the Department of Rehabilitation and Corrections, depending upon their analysis of your case, which means it could be extended to 1.5 years or a total sentence of 4.5 years. Now, according to the sheriff, you've got 25 days of jail time credit, picked up most recently on May 5th, released the next day, May 18th, and with 3 other couriers who were in jail twice in 5 days and once in 2 days, for a total of 25 days. Now, upon completion of the prison term, whether it be the mandatory term that's required or any additional term that the adult parole authority may impose, it is possible that, or I'm sorry, it is mandatory that should be put under post-release control supervision under the supervision of the adult parole authority for a minimum of 18 months up to a maximum of 3 years. So you will be supervised once you complete the prison term. No ifs, ands, or buts. By a parole officer, not by the court, of course, not involved. And if during that period of time you fail to comply with those conditions, they can return you to prison. You will serve the entire term set by the court for an additional period of up to 9 months for only a single violation, up to half of the prison term imposed by the court, which is 3 years. So that would be 1.5 years for multiple violations. And so that's the cap. However, if you commit a felony while under post-release control, then an additional whatever sentence would be imposed by the judge in that new case. That judge could also sentence you for committing that violation while under post-release control in this case to an additional period of 1 year or times left on the post-release control period, whichever is greater. If that occurs, that had to be served consecutively the sentence in the new case. You understand that? Now, you're also ordered to pay the court costs of judge granted and execution order. If you fail to pay those or collect that for various means, including levy on bank accounts, wages, earnings, or other assets you have, that doesn't collect it, then once you complete your prison term, not while you're in prison, the court could permit you to do community service in this county and give you credit for each hour work, an hour raise out of the court. Each hour work will reduce your judgment by that amount to pay in full. You're also ordered to make restitution jointly and severally with your co-defendant in the amount of $1,310 behind the county dashboard. That's a substantive order, so it follows you no matter whether you serve your police sentence or not, as far as an extended period of time, Department of Correction, beyond the mandatory offense. And it can only be removed by either payment or dying. So it can't be discharged in bankruptcy or anything like that. That can be repaid through the victim witness escrow account, restitution escrow account, and you can pay any fees associated with that. All right, is there anything further, counsel?
Did you waive your mandatory fine?
No, I did not. Given the fact that this is a mandatory sentence, that's in the court fine, she does not have to go to the case, mandatory fine presently, nor will it likely in the near future. Therefore, the mandatory fine is waived. All right, you're ran back to custody, man. All right, we're getting Mr. Kramer. I'm going to go ahead and do Mr. Taylor from the stars of the pre-trial. Justice Taylor 22 CR 48. Alright, case number 22 CR 48, State of Ohio versus Dusty Allen Taylor. And you are Dusty Allen Taylor, appearing from the Star Athens video stream. Alright, this hearing is being conducted by Zoom since Mr. Taylor is 100 miles away. His attorney is Captain Hacker, appearing from her office. The prosecutor, Collins, is appearing from her office. Bench charged with breaking and entering theft, 2 counts of theft, 1 fifth degree felony, 1 a first degree misdemeanor. This is a, I believe it's first pre-trial, final pre-trial, okay, we have a separate video. Okay, we have a trial date set, June 13th. Alright, now is discovery complete in this case? I think, Sergeant has happened, did file yours, and already, there's been no pre-trial motions I see, is that correct?
There's not, we've received an offer, and I will take full responsibility for this. My office now, the plea offer and the discovery to Mr. Taylor, unfortunately, my gal mentioned some matters, so I did not realize that until just this morning. So I believe we'll have this resolved, but we could just have another week so I can actually get it to him.
Alright, what we'll do is, I'll go ahead and wait the 14th day, I'm gonna be, available next week, but, we can get it worked in, after that, and, we can do it on Zoom, and, if necessary, we'll vacate the trial or continue the trial date. Right now, I'll just leave it on, and then, get information in, talk with him, and if you get a resolution, contact the, sign commissioner for scheduling the date, and we'll do a hearing by Zoom.
Would it be possible to designate break out room while you finish up?
Absolutely. All right. Anything else from council in this case, Ms. Collins? All right. Okay, I will look at that close and reschedule here.
Thank you.
Okay, great. All right, there should be a button there, Mr. Taylor, if you push it says joint breakout room. There we go. All right, are you Harold Kramer there at the jail?
Yes, Your Honor.
All right, case number 21 CR 48, State of Ohio versus Harold J. Kramer. Mr. Kramer is appearing by Zoom from jail. His attorney is Danielle Witt. She's appearing by Zoom from her office. Representing the state from her office is attorney, prosecuting attorney Collins. Ms. Witt, you and your client both agreed to conduct this sentencing hearing by Zoom remotely rather than in presence, in person appearance at the court.
Yes, Your Honor.
You're agreeing with that, Mr. Kramer?
Yes, Your Honor.
Your Honor, we have a discrepancy in case number. You had 48.
I'm sorry. His case number is 21 CR 201.
There we go. All right.
Mr. Hayes.
Okay. Thank you, Your Honor.
All right, thank you. All right. Mr. Kramer has entered plea of guilty to breaking and entering under 2911.13A, a fifth degree felony. The matter was referred to the probation department for a pre-sentence report. Also referred to the drug court coordinator, and I have a letter from Sturgill indicating that he has screened again and he appears to meet clinical criteria I do also have an application in the file that we signed requesting to be admitted into the drug court file. Now, I also received the pre-sentence report, and each of the attorneys had an opportunity to review the summary.
The state has, Your Honor, did not review, Your Honor, but we discussed the contents of the probation permit this morning.
Okay. All right, anything from the state?
Yes, Your Honor, the state is recommending the defendant sentence to a term of incarceration of 11 months. You would first note that the victim does not approve of this defendant being drug court. The next note, the defendant has 4 prior felony convictions. And in this crime, honestly, he must have been out of prison about 5 minutes because June 25th of 19, the defendant told the vote that he was sentenced to 30 months in prison, and this offense was committed on November the 7th, 2021. So he must have had some good time credit or star or something like that, and was released and immediately committed this offense. He's been starred on at least 2 prior occasions. Crimes are not solely drug-related crimes. For example, in 05, felony burglary, he was given 3 years in control for. Then a trafficking heroin and heroin, he was given community control, violated again, ordered to be starred, violated again, and then was for some reason just given 60 days in the county jail. And 19, an illegal conveyance and active possession of drugs, 2 years community control, violated, revoked, 30 months in prison, got out, again, like I said, about 10 minutes later than this crime. We would note that, again, there are victims in this case, and they did not include consideration for drug court, either this state. We are asking this defendant to term for incarceration. Thank you.
Swift?
Yes, Your Honor, we do ask the court for consideration of drug court, while as the appellant stated that Mr. Kramer does have a history. It is my understanding that the co-defendants in this case did receive community control, at least 2 of them that I'm aware of did receive community control with that. And admittedly, when I spoke with Harold, he talked about how excited he was for this opportunity to change his life and start clean and to break free of this cycle. As Tom stated, he does have a history and he has no problem serving the prison time. However, feels that it would be better suited to actually have a support system such as drug court and looking to fix his life instead of just band-aiding it and repeating the same cycle over and over again. But I'll let him speak to that.
All right, Mr. Kramer, anything you'd like to say?
Yes, Your Honor. First, I want to apologize for being in front of you. I did get out of prison when I got 5 days in my father had passed away in 2019. In 2017, 2019, my father passed away. It just, everything went downhill from there. And if given the opportunity, I have been a 23rd recovery council in Waverly. If given the opportunity, I would not let down, take a work, I would finish working and finish my rehab and do everything I can to stay recovered and stay recovered for me.
Okay, let's see, Mr. McKee was one of the co-defendants, and I think he had other cases before the court. Was he given community control?
No, he was not. He was sent to prison. His other case was started to appear.
That's
The people that were given community control have no prior felony. They're listed.
okay. Mr. Van Hoos?
Yes, as well as the female.
Yeah. Got her name, I don't see it here.
It's Salon.
Oh, yeah, I remember her name, yeah.
They have no prior felony convictions, so they're possibly 6 terms.
Well, Mr. Kramer, one of the things that I noted in the information report and interview says that you have a good history of complying when you're locked up, but not when you're not you're out. And this problem just kind of went over that. Now, you had a 2-year period of sobriety and you found that. You know, I'm so tired of hearing people complain about the lapse because of death. I understand my wife died in December. I didn't get drunk to go start using drugs. You know, it's an excuse. You know, I mean, I know it's a stressor, but there are ways to deal with that. And if you had just relapsed and the drug offense possession charge, then I would feel differently. But it doesn't give you carte blanche to go out and steal from people, break into their places, and victimize people. And you know, I just don't find that in the end, because you had, what you said, your father died 2 years before this semester, over 2 years. So you had plenty of time to deal with that tragedy. So to come here and say that, you know, the death of your father 2 years ago still caused me to commit crime in 2021, you know, I'm just not mine. Just not mine. Right. So it's a judgment over the court that you be sentenced to the correctional center in Ohio for a period of 9 months. You can get credit for this is a mistaken thing. What day was he arrested? Were you arrested March 30th?
Yeah. Yeah, I was going around County Government for 5 days.
So was that the 30th where you were arrested in Brown County? Is that the day you got here?
I believe, yeah.
It was, they showed me on that day.
So you had 4 days in Brown County?
Yes,
I did, that's 20 days, close to that, so, March, okay, so we're gonna say March 26th, they have 30th. That'll be 5 days in March, 30 in April, 18 as of today, in May. So that's total 53 days you got time credit. Now, upon completion of this jail term, it is possible that parole authority will put you in under social control for a period of up to 2 years. They don't have to. Again, if they do supervise the terms they set by a parole officer, and after that period of time, they determine that you have to comply. They can return to prison, making sure an additional period of up to after your prison term for one more violation. But the condition has been found, and in addition, whatever sentence the judge in the case of closed finding, that judge is also authorized to sentence you for committing that offense while under social control in this case for an additional period of 1 year, whatever times that on social control is greater. That occurs, that has to serve secondly sentence in the case. You're also ordered to pay court costs or judgment grant execution order. If you fail to do that, then the court could, or you do service, you credit for your work, and then earn a rate sent by the court. Your work, reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
Yeah.
All right. Any other hand discussion? All right, I believe that's it. I don't have anything.
We have Mr. Williams here, 10:30, 10 a.m.
I was just gonna let you know, Dustin Taylor, I did the breakout room, we have resolved the case, this is the set for the hearing.
Okay, good. All right, thank you. All right. Okay, I believe that completes our Zoom session.
Are we doing that?
Yes, Mr. Williams, 10 a.m.
Yeah, 10 a.m.
Yes.
That's in person. Yeah, he's here.
Okay.
All right, I believe that completes the Zoom docket this morning. All right, I'm taking a break here.
Okay, please rise. Have you met with your counsel?
Yeah.
Okay, he's out there. Okay. Have cell phones on you? Okay. Ready? Come on up. Have a seat here. Stand. That's it. Or you can stay standing. That's it.
One thing that you come on the butt.
You gonna call Brody's case next?
Yes, sir.
I've seen your brother.
He said our pews aren't too comfortable. Stand for good.
You know, hard.
Oh, is that right?
Yeah. I'm all right, but I'll make it.
Hey, Dan, this is,
Still wants to be. Oh, right.
text.
Good, right?
in a minute.
She must think that I give her powers. Okay.
Please rise.
Okay.
PSI, 15,245.
This is the link right now.
Yes, sir.
Alright. Case number 15 CR 245, Stableheim versus Brody Williams. The state is heard represented by Assistant Prosecutor King. We're going to have defendant is trial. Defendant was convicted in this case. Aggravated trafficking in drugs placed under control on December 9, 2015. 33 years. It was terminated successfully on June 13, 2017. The defendant has filed an application for leave of disability, which I believe actually, in terms of not mistaken, is supposed to be on civil procedure. In the county in which the defendant resides. Is he reside in Conn County? Yes. Okay. But I'll weigh that procedure leave back in the future. I want to take a look at the statute. We've had several of these. It's actually considered a civil procedure. All right, Mr. Armstrong, wish to speak to the.
Then we submitted on the motion state that Brody, the court just pointed out, has successfully completed his probation. It's my understanding that you can't be on probation for something the offense resulted in you losing the gun rights at the beginning to have been his felony conviction back in 2015. I would state that he is considered on probation now for a physical control charge, but it's only until his fines and costs are paid, so he still owes some fines and costs out of county court. I don't believe that's an impediment to these rights being granted. He wishes, if the court has a different opinion, I guess I would ask that this matter be continued, because I think we're in a position to pay those off and terminate that probation. So the court think that's definitely we can deal with that. Beyond that, his desire is to be able to basically come with his son, Your Honor.
Okay.
State has no objection to the application, Your Honor.
Been any further that's other than the OBI?
No criminal offense, Your Honor, no.
Well, I don't have the statute in front of me, so what I'll do is take it under advisement. And give you an opportunity to file a memo to set forth whether or not there's any authority on that proposition. And barring the current probation issue, or grant that, it needs to be held until he gets that paid off. And under the law, the way they operate out there is you're under probation. And here we terminate you and let the clerk proceed flat. But maybe you can open that area for a long time. I feel like going on with that or something. But anyway, it's still valid probation order. I have some reservations on what I grant until that expires. So what the remedy would be is on proof of the police and the police sign order.
I didn't look at any case law. I did review the statute yesterday, and it did appear to me that that's what couldn't be on probation for what college of lose your rights to begin with. It didn't talk about anything, any other probations, but I'll see if there's any cases.
Okay. All right. Thank you. Okay, Wesley Howard. Next, you need to All right, this is case number 220117, State of Ohio versus Wesley A. Howard. Mr. Howard, President of this council. Now, there was actually a superseding indictment issued on this case in May. You have a date you're supposed to appear for Raymond, son?
No, I was going to pick the summons up right after I left here.
Okay, all right. So you have to receive that indictment. All right, you'll have your, I think we're already people on that line. Forget what it is. Schedule that's the time off the month. All right, so this matter sets the trial, I believe, in July. After they created this trial, the first one, and the draft was filed at motion for all. Address that matter.
Good morning, Your Honor. Judge, I'm respectfully requesting the court to allow me to withdraw from this case at this time. I believe that there are professional reasons, differences between myself and Mr. Howard that make my withdrawing necessary.
What would those reasons be?
Your Honor, I don't believe that it would be appropriate for me to list those on the record or discuss those with the specific with the court at this time. I think that there's a consideration of Mr. Howard that would prevent.
What is the difference of opinion as to strategy or defense growth or what? Is it something of that nature?
Defense approach, perhaps, Judge.
Well, here's what I'm getting at. Defendants have a right to have effective assistance counsel. That's constitutional right, you know. There is no similar amendment that applies to attorneys. Attorneys don't have the right to have the effective assistance of their clients. If they have a client that's not listening to them, doesn't want to follow their advice, wants them to do something that's recommended against, that's not sufficient reason to withdraw this board view. So that's what I'm getting at. Is that what the situation is?
It's not just a situation of Wesley not being inclined to take advice. No, sir. There's more to it.
Well, I don't know how I'm going to grant something on when I don't have any evidence for it. I mean, you're going to have to give me something. Because we got a trial coming up in July. Yeah, well, let me ask you this. Have you obtained another attorney?
I'm seeking counsel right now. I'm supposed to have a meeting with him this week.
And you have identified an attorney? You identified this attorney?
No,
You have a point. All right. And you have a means of employing counsel?
to talk to them.
Pardon me?
To talk to them, yeah.
Yeah, and have, maybe told them what the trial date is and it's not
Yes.
going to be continued?
Yes.
Because, that's the concern I have. I got this trial date, and we've got a whole bunch of stuff going on, and I'm not,
I told him.
we've had a lot of issues getting this, so getting an attorney and then ready to try it.
Yes, sir.
Well, this time I'm going to deny the motion, subject to renewal, on the basis that he's seeking counsel, and if he does obtain counsel, I'll grant it. But if he doesn't, then at that point, Mr. Rack, if you want, having a camera hearing or something of that nature, then I'll entertain it. But I've got to have some basis of why you're you've been to withdraw this far as that case, because it's a complex case, and I have some questions later. I get another attorney. I'm going to be ready in 6 weeks with this big trial. We've been talking all along about how this was. There was a lot of evidence, a lot of time. So, I need to see some compelling reason why it's, not possible or not going to be recorded. And I think you represent vigorously and, forcefully and confidently and, reason this point to allow withdrawal unless you get the counsel. Or there is a reason that under the law would compel the court to allow you to withdraw, and that has to be in the record somewhere. So at this time, it would be not. All right. So, you get your night next week. We're going to get, there's a limit date on that.
The arraignments,
Actually, I'm going to be able to, here. Maybe in here, oh, yeah, it was yesterday, 8:30. So, you can go get it today. And, Mr. Rack, for purposes of that, trying this, you want to get it. Have you seen the indictment yet? The superseding indictment?
No, sir. Frankly, Judge, I was surprised. I met with Wes a couple of Fridays ago. I was under the impression that the superseding indictment would have a different case number.
No, superseding indictment goes into the same case.
It does in this county, but it doesn't in others, which is my
I've been in other counties that does, but some don't, so it just
Yeah.
depends on practice.
So, my understanding at the time was that there would be a new case number. I know that there's new counsel that have been appointed for the co-defendant, and for that reason, frankly, I had no intention of designating under what I thought was going to be a new case number. So that's my mistake, and I apologize.
Well, I mean, you want to get an arraignment date set up after you fix up the indictment, you look at it, or you want to just go ahead and waive, you gotta ask her, so. If you want to go get the indictment, look at it, come back, later, do it, or you can set it up as a, something like that. But you need to go get it, because, I'm not going to violate your contract, that's pretty good. Next time you get a, I mean, have this happen again, you get something, you need to get bigger. Some of you guys had a good appearance on your, trial days and so forth.
Judge, is that what does the sheriff's office or the clerk of court have as indictment?
Sheriff actually has service for it.
Does the
unless,
capacity?
We can serve it.
See the ability to bring it here to the courtroom?
We we can actually get a copy and have one on our table, so we have to serve.
I'd ask them to do that.
Let's do that, then we'll take a break.
Unless they may have converted that, Your Honor. Since the Raymond's were yesterday, they may have converted that to a warrant.
No, I had to sign over on that, that was just yesterday. So, just, Ben, go down there. I mean, I don't have anything else on that specifically, so we have mine, so we'll wait on that. I haven't looked at it, I don't think, I thought what they were doing was adding the, individual count, they added consent to the, case, and then maybe the ones that they were talking about that weren't charged. But I don't know. I haven't looked at it. Then we did observe that we did get something for training yesterday. Superseding indictment, so, yeah, and then we're gonna have clerk issues, new papers and, serve him and bring in a few minutes. So, okay, so we'll take care of that.
Please rise.
How you doing today?
I'm not too bad. How about you?
Well, same. It's a little chilly out there.
Could it be any better off unless you run court today?
Yes, sir.
Summons reissued per prosecutor with correct case. 64 is the old case.
That'd be me.
117 is the new case. Find out from the judge. We don't want to take anything he's already had it done, but I just say with loose status charges, when it had his permission. Pardon me? That's what the judge wanted to send up here so he could review it. He's here for.
William Jordan. They're bringing him from, got the sheriff's department.
That's not till 1 o'clock.
1 o'clock.
1 o'clock.
Are they bringing him here?
It says it's to be, he'll be, according to the notation that the assignment commissioner puts on here, he will be doing a Zoom computer hearing from the jail, but he will be brought back to the Highland County Jail for that.
Okay.
But so he will not be in the courtroom.
Okay, is there any way they could let me see him?
Nope.
They don't want me to.
No, they don't even allow visits at the jail. You have to do it by video
Okay.
and Zoom.
So they do. So they're not gonna bring him here?
Yeah, that's correct. If the notes stand, it's correct. It says be brought back from prison and be a jail Zoom, which means they'll bring him from whatever institution he was at to Highland County Jail, and then he'll get on the computer out there and be on the computer with the judge here.
Well, I didn't see him in a while, I just.
Yeah, I understand. Okay.
Thank you.
You're welcome.
That's crazy. You think they do it for that institution?
Well, they do sometimes, but and
That
see,
case.
depends on what layer he's at now. He's at his final pretrial. So that means his attorney will want to sit down and talk with him, so they bring him back so they can do that. That way the attorneys don't bill for $75 an hour to drive to wherever they're at an institution. So what case are you? Thought you'd been here a while. You got time to go get a burger or something? It's 10:45. You got 3 hours.
Thank you.
Yep. Sometimes you wonder why people are in trouble when they realize they can't read. Another one. I can't believe this. I'm going down through here and thinking that name's familiar, and they're all on today for other cases, previous cases. So we need that. Which one? 111. We need 111. And he's supposed to be here too. He was here. He's been here all morning. I said, "What case you here for?" And he told me his name, and I said,
Who's returning?
He doesn't have any. But he's got another.
I gotta run down there again.
You want me to get it?
I'll get there.
I mean, I'll get it. What they gonna do here? Just go through it. Have you already been out to the sheriff's office and had fingerprints and mugshot taken?
For this?
I know you haven't for that one. But
Yeah.
for the previous one.
Yeah. The original 12 count in September, I did this.
Okay. And you'll have to take that one out there and get it done again.
Yes, sir. So that's the criminal enterprise now, October 10th.
No. It could be,
Oh, wait for me.
change the first.
Oh, let's go. So now we're going to use 2021.
All right, we're back on the record on state power. Let's see, on the 64. I have now showed that Mr. Howard and Chief, we summoned the company indictment, is that correct?
Yes, sir.
Okay. You waived the indictment, Mr. Pratt?
Wes, do you waive reading of the indictment?
Okay. How do you think?
Not guilty.
All right. Court then accepted plea. All previous orders, scheduling orders that have previously been issued will apply in this case to the superseding indictment as well. Subject to any further motions that might need to be filed or requested concerning the changes that were included in this indictment. And so the same court occurrences and everything still apply. I don't know if we have any further pre-trials or status conferences, but if there is a need for one, and or if you decide to make a motion, Mr. Rackmore, if you get the attorney who does interference, at that time, I'll make it right to withdraw, but you need to get on that real block after that's going to be your decision. Right, thanks.
Please rise. Okay, Security. Council.
Now, I just have one question, because it's just too
should be taking the June 6th trial off the schedule because actually there should be a dismissal entry filed on that case number. There might even already be. He had this big case and he had a 1010
Yeah,
case.
so-
The 1010, there should be a dismissal entry and it may already be on there.
There was a bunch of papers inside the cover of this new indictment, and it said to replace indictment number such and such, so it's probably all that together. So, and you received an assignment notice, something that looks like this, it had your name on it and the hearing dates and all that, you received that. As he said, all those dates are standing, okay, so make sure you have that. You're here, stay in touch with Mr. Rapp, let him know what his obligation is, but if you're gonna get another attorney, follow his direction.
Thank you, sir.
Thank you. Did they acknowledge they could hear you?
Brian, can you hear me? Can you hear us? Yeah.
They've got everything muted out there. Hi, this is Dan, Common Pleas Court. Magistrate Williams has a hearing set up, a Zoom, or it's supposed to be a video conference with Spurlock. Supposed to be down in the video room, and I don't know if they've left it on Zoom from this morning or if they've got it set on video, but they can't hear her. Can you see them?
Yeah,
She can see the room, and there's somebody there in the room, but nobody can acknowledge us up here. Okay. All right, you're sending him up there? Okay. Okay. Yeah. Hey, this is Dan, Common Pleas Court. We are not getting anything from the video room. Okay. Magistrate Williams can see them, but they cannot hear her and respond to her. So if they could check it out. It should be in video mode. We're not Zooming. There's no attorneys involved, so it's just a video conference. Okay.
Brian, can you hear me now? Brian? Can you hear me?
Can you hear us, LT?
That's why I'm talking to myself right now.
Can you hear us?
I said, I don't know what switch you guys got to pump over there.
Yeah.
What switch? Are you calling me?
Magistrate Williams is speaking on the camera.
Yeah, man.
We can hear you guys now, but I don't think they can hear us.
I'm sorry.
We can see and hear you.
You just walked up on the bench. Stand upside down. So the camera right behind you is the one showing you. Ever been? No. Behind you, right there. There it is. Morning.
I say shut it down or back out.
I can hear her.
Can you hear me?
Where your guy is.
Okay. Okay, let's do this. Turn it off. I'll turn hers off and we'll call you right back, okay?
Alright.
All right, thanks. Too much technology. Yeah, everybody.
It's just a 2-minute hearing. It'd take longer to log in.
Okay, I'll pause it since we're still playing.
So going back,
I've got this on video conference, correct? Civil.
this is just 2 minutes.
Zoom, use the address from this morning. Call the shot chief. Use that same address. That, you get out of the video, and go back to Zoom. You just won't have to get turned on to anybody else. We don't need it. We gotta Zoom this off the meeting. I don't think it matters. I don't think it matters. I get to log into what we did this morning, as long as we got it on the jab.
The judge didn't look at it here. Who was it that?
Cases.
Are you doing, you cap versus
EduCap Incorporated?
Here, the criminal hearings all.
Yeah.
Start that right now. And go back into what you had this morning. Recording in progress.
We had Lathy, Fleming, Kramer, Sloan.
Yeah, total law back in. Where's now?
Yes. Are you on video conference?
I'm on Zoom. You want to go back to video?
There.
Can you hear us now?
I can hear you, but
All
the
right. We can see you, we can keep,
Can you hear me without the camera? Can you hear me?
I can hear you, but you got the same camera we had before.
Okay, so we're back to normal, right?
No,
It's supposed to be that
the
camera.
camera up there, the one up behind you, man. Camera behind you, right there. Yeah, that's the camera showing.
Can you see us?
I'll face that way, how's that? As long as you can hear me. This is just a 2-minute hearing.
Okay, let me get us started.
Hold on for a second.
Are you ready, Magistrate?
We're on the record that Spurlock versus Spurlock, case number 09-92. Case before the court is a hearing that Mr. Spurlock is held on a habeas for non-appearance of child support hearing. Mr. Spurlock, you were ordered to appear at hearing on March 17th and failed to appear. Can you explain to the court why you didn't appear that date and time?
Yes, I was incarcerated in Clinton County. I wrote the judge a letter.
And you were just recently released from there, is that right?
Yes, I was.
And so, Mr. Spurlock, what is your current address? And if you were released from incarceration, where would you be living?
74 Orchard Avenue, Sabina, Ohio.
And who should be there with?
a friend. She's,
And her name?
it's, it's Junior Hubbard's, Nancy Hubbard.
And you have a phone, sir?
No, I don't, not at the moment. I did have one, I got incarcerated, but it's kind of lost now.
Okay, and do you know anybody's phone number that we could use to contact you if we need to?
Yes, yeah.
Good.
Are you ready?
Name and phone number.
Brandy McCord, and 937-302-8243.
Sir, if I reschedule your hearing for August the 4th at 1 p.m., will you show up for me?
Yes, ma'am.
Because I'm not going to write up to keep you in there until that hearing date if I want to, but give me your word, you're going to be here, that's all I want, I just want you to show up.
Yes, I promise I'll be here.
Okay, so I am going to order that you be here on August 4th, 2022 at 1 p.m. on Police Court, Highland County. Okay? We'll send you,
Okay.
I'll send you a written notice after the jail, extra copy of the injury, and the signed notice, I want you to get that before you leave, once you receive that authorization. Any questions?
Okay. No, thank you.
Nothing further, merger.
You're welcome. And we're zooming. And on the record.
All right, this is, Educat Inc. versus Julie Smith, Saddle Bowles, Cleveland CD 100. This is a pre-trial, not pre-trial, being done by Zoom. And you're making an urban appearing, from your office, on behalf of the plaintiff?
Yes, that's correct.
All right, and, you are, it says Julie Freeman, is that your name now? Used to be Julie Smith?
Yes.
All right, so you're
Yes.
now, Ms. Freeman, okay?
Right.
Okay. All right, the, matter in this case, I believe, set trial, June 14th. And there was a motion for summary judgment, the court granted summary judgment regarding liability, but, since there's been a letter sent by this, Fryman, which she's not disputing liability, but disputing the amount, or didn't feel that there was sufficient evidence to grant summary judgment as to the damages, of course, did approve that. And what my hope was is that, Ms. Urban and Ms. Fryman, that you guys have talked, and, perhaps, the plaintiff would be able to provide the payment history and account to be able to, demonstrate what's owed, so you do admit that you know something, but not, prove to the amount of side. Now, has there been any conversation between the two of you?
There has, we received a call with an offer to review with my client. They do have a counter offer, which we tried to, pass along this morning, but I haven't just.
Okay.
So.
All right.
I don't have any missed calls. I am at work, but I do not have any missed calls from their office.
Okay. What's your phone number? You're going to get that to her so she has it right now.
740-851-2784.
Okay. All right. Well, I'll just, I assume what we're going to have is an account and a witness to verify the account how it was conducted, and this, Freeman, you have your own records that, that would show that you made payments that were not properly credited, or if you have information or evidence that shows that the interest or penalty has been incorrectly computed or something like that, that's what I would be looking for in making that decision as to what is owed. And so, the court can't figure it out on its own, has to rely on whatever evidence is presented. And so, if you have that kind of information provided to Ms. Urban, I'm sure that she'll provide it to her client, and they would look at it to see if they're having a custody. I've had no more than one case in which accounts were not accurate over the years, state county. And sometimes payments are not posted to the wrong accounts, or something like that nature. So, if that's happened, that's what things you need to be able to discuss. And if that kind of thing happened, I would guess that Ms. Urban and the client will agree if you showed that they made a mistake. If they disagree, then and if they explain it to you, and that perhaps you'll understand and look and see that what they're saying is correct. I don't know. But she's indicated there's a counter offer, so I don't need to be involved in that, but, you know, the two of you, we continue to discuss this, maybe get it worked out, and we won't have to have a trial, but if you don't, then we'll have a trial. Now, this, Urban had contacted the sign commissioner inquiring about, remote, hearing, and I do remote, hearings all the time. If you two want to agree with that, I would need to have, you know, agreement, by both of you, in writing, stating that you agree to that. And then the exhibits have to be pre-marked and given to me before, get it to me, because I need those in hand here at the courthouse so that I can look at them. They do need to have their own copies exchanged with each other, so everybody's looking at the same document. And if there's a witness going to testify remotely other than you, Ms. Brian, then, and also if they have a plaintiff, then they would need to have a copy as well. So everybody's looking at the same thing. And you can do the screen sharing this, Urban, so that, you know, you can show on the screen. But one of my, I've done lots and lots of Zoom hearings, and one of the things I found is it's really hard to follow exhibits on the screen. And also listen and see people, so it's easier to have the document here. I can flip back and forth at things quicker than I can with someone else's control of the document. So if the two of you want to discuss that, I would be more than happy to do this remotely and, you know, it's pretty soon. Okay? All right, anything else, either like for him?
No, if Ms. Urban can speak. Now, I'm covering my taxes. We weren't able to get a.
Let me put you into a breakout room, and I'll go ahead and leave the room and mute mine, and you guys, when you guys are done, then we'll just leave the breakout room, and actually, I think I'll tell you what I'll do. I'll just leave it on. I'll turn down the volume, and I'll step off the bench, and then when you're done, they'll be able to disconnect. Okay. And when we do have the hearing, Ms. Ryan, it'll be better if you're at a fixed location.